Good morning, everyone. These are the detention hearings for the 323rd Judicial District Court of the state of Texas for Friday, March 12th, 2021. The Texas Supreme Court has recommended that we keep the in-person hearings in this court to a minimum. However, in keeping with the open court's provision of the Texas Constitution, these hearings are being broadcast live on YouTube to provide the public with meaningful access to the courts. Rebroadcasting or recording all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. Our first hearing is Amari Rashawn Brooks. Are you Mr. Brooks?
Yes, sir.
Mr. Brooks, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day detention hearing. You have the right to remain silent. You also have the right to an attorney. And is Ms. Smith here?
Yes, Your Honor, I'm here.
All right, good to see you, Ms. Smith. The court will take judicial notice of the fact that Judge Kim has previously determined that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention and entered a finding of probable cause. According to the records provided to the court today, you are level 3 confined, if for no other reason than visiting inappropriate websites during school using your Chromebook. Before I can even consider you for release, Mr. Brooks, what does your detention level have to be in the back?
1 outside.
1 outstanding, correct?
Yes, sir.
You're not there, are you?
No.
You're not even close, are you?
Yes, sir.
What do I have to do today?
Hear what?
What do I have to do today? Detain you or release you?
Time.
Why?
You're not the one outstanding.
That'll be the order of the court. Thank you, sir. Thank you, Ms. Smith.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Good to see you.
You as well, Judge. Have a great day.
Lauren Anna De La Rosa.
Hello.
Good morning, Ms. De La Rosa. How are you?
Good morning. I'm doing great this morning.
Good. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Taylor, is here. Do you see Ms. Taylor on the screen?
Good morning.
Good morning.
All right. The court has previously found that probable cause exists to believe that you violated a technical condition of your probation sufficient to warrant your detention in our facility. You have a hearing scheduled before Judge Kim. Let's see. Is it next Thursday or a week from Thursday? Week from Thursday, I believe.
Yes, the 23rd.
Ms. De La Rosa, before I can consider you for release, what does your detention level need to be in the back?
1-0.
What is your level today?
2-0.
Okay. So what am I supposed to do? Detain you or release you?
Detain me.
And why?
Because I'm not 1-0.
Uh-huh. Now, if you're not 1 outstanding, you're making Ms. Taylor's job very, very, very difficult, because Judge Kim will consider that at the hearing on March 23rd. So you want to do your best to get to level 1-0 and maintain it. That will put Ms. Taylor in the best possible position to fight for you, okay? As for today, I got to order that you be detained. Thank you, young lady. Thank you, Ms. Taylor.
Thank you, Judge.
All right, next, Dania Johnson.
Yes, sir.
Are you Mr. Johnson?
Yes, sir, I am.
Mr. Johnson, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And there's Mr. Daniels. Do you see Mr. Daniels on the screen?
Good morning, Jeremiah.
Good morning. How are you?
Good.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. Is that mom and dad in the family room?
Yes.
Yes, ma'am. Yes, sir.
All right. Jeremiah, Did Judge Kim go over the detention levels with you in the back?
Yes, sir, he did.
And what did he tell you your level needed to be before I can consider your release?
A one acceptable,
No, one outstanding.
one outstanding.
Uh-huh. But you're not even level 1. You're level 2, right?
Yes, sir.
Okay. Part of the reason why Judge Kim and Judge Terry and I make y'all get to level 1 outstanding is because that proves to us that you can follow the rules in the back. And if you can follow the rules in the back, then we have better confidence that you can follow the rules at home. And so that's why we make y'all get there and maintain it. You haven't been level 1.0 since the beginning of the month. So you're kind of struggling in the back, right?
Yeah.
I need you to work on that, okay? I need you to get to level 1 outstanding so that you can prove to me, so that you can prove to your parents, so that you can prove to Judge Kim that you do know how to follow the rules, all right?
Yeah.
Can you do that? All right, but you're not level 1 today, so what do I have to do?
Detain me.
Yes, sir. Mom and Dad, have you been able to talk to your son while he's been in detention?
Yes, we have.
Okay, that's real important for him that y'all keep up that communication and encourage him to get to level 1.0, okay? All
We
right,
have been doing that. Yes, sir.
thank you so much. Thank you.
Thank you.
All right, that'll be the order of the court. Thank you, Mr. Daniels.
Thank you, Your Honor.
I love you,
I
Jeremiah.
love you, Jeremiah.
Okay, Mom.
May I be excused, Your Honor?
Yes, sir. Good to see you, sir.
Good to see you, Judge.
Demarvion Meredith. Okay.
First name Marcus. Yeah, see what they're doing. Yes, sir. Thank you.
All right. How are we doing on getting Mr. Meredith?
This is Demarvion's mom. He's not in detention. I was told to come here for a show cause hearing.
Okay.
He's actually in detention in Denton.
Okay. Thank you for reminding me so much. Okay.
Your Honor, this is Karina's case. She just called me saying that she's having technical difficulties, is not able to, well, okay, Karina,
wait,
try and
wait,
talk.
can you hear me now?
There you go.
Yes, Your Honor. I was just going to let you know he is in the Denton County Detention Center on a probation violation, and Mom did contact 3 attorneys for the show cause hearing.
Okay. Okay, after reviewing the application, the court cannot make a finding that the family qualifies. So I'm sorry, Mom, you're going to need to continue to search for an attorney for your child. But in this case, you just don't qualify. I'm sorry, for a court-appointed attorney.
Okay.
How much more time do you need to get that taken care of?
I would just have to contact, them. I could probably do it by the 23rd if I had to. But I mean, I know it doesn't look like we qualify on paper, but we've been getting lawyers for him for the past 4 years. So.
Okay. All right. Then, Ms. Rodriguez, if you'll make that notation, and we will meet again. Let's see. Let's reschedule this for Friday, the 26th. That way we don't lose track. Thank you.
Thank you.
Marcus Riley Miller. Morning, Miss Abels.
Good morning, Judge.
You can go ahead and identify yourself. Your Honor,
Right.
Judge Porter, I do have a CPS. It's not the parent, it's CPS here in the parent room.
I am his active CPS caseworker, Your Honor.
All right, great. Are you Mr. Miller?
Yes, sir.
Mr. Miller, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Ms. Abels, your attorney, is here. Do you see her on the screen?
Yes, sir.
Back on March 2nd, Arlington Police Department referred you to the Juvenile Probation Department for the offense of criminal mischief, valued at damage causing more than $2,500, but less than $30,000 worth of damage. According to the report, shortly before noon, officers were dispatched to Millwood Hospital in regards to a patient causing damage to staff. They identified you as somebody who came upset while in treatment and acting out by jumping on the nurse's station desk, allegedly damaging a desk, a monitor, a vital signs reader, and other property, and causing damage valued at least $3,700.
Yes, sir.
Oh, and you're also on probation with Smith County out of Tyler.
Yes,
All right,
sir.
but you've been level 1-0 for the last 2 days. Yes, Ms. Brazel.
You got this.
He is pending charges in Smith County. I did hear from the PO in Smith County, and they are set for court on the 25th for that misdemeanor assault.
And Judge, we're set for court on the 24th, and CPS doesn't, the only placement, my understanding is the only placement CPS has for him right now is in the CPS office. Marcus is at 1-0 here, which I think is good. I think is where he will be the least amount of problems for himself and for others if he were to remain here. Marcus, I'm sorry. Just don't have anywhere else for you to go. And so I think that if he remains here, and I know you're mad, baby, but if he remains here, we can get this court hearing done, give CPS time to hopefully find a placement for him that's close to Smith County, or, you know, we can work something out between counties to get things settled. I don't know.
Your Honor, could I offer some on this? I would like to let it be known that the whole week he was at the hospital, he was very volatile with the staff there at the hospital before he had the incident that required his arrest. He has assaulted caseworkers in our office the last time he was placed in the office. And I faxed a request for records on case ID 2021-006-10317 to the police department, because I believe he is currently a party to that case, and that he assaulted a child in that same day. And those charges I'm waiting to get the word back on if those charges were filed against Marcus from the parent of the child that he assaulted.
And I can add that I have personal knowledge that Millwood Hospital is not a very good hospital, is probably not very protective of their children that are in their care. And I'll be very interested to see the report that he's requested, to see if maybe Marcus was not the only one participating in that.
Are those factors that I need to consider on whether to detain Marcus or release Marcus to a parent or guardian?
I think the factors that, I think what I want you to understand is my answer is no.
Good answer.
Thank you.
We have several hearings today. Let's try and stay on task.
Okay. And I think the point is, I think he's safer here than he would be if you send him back to the CPS office and there's no other place to send him.
Okay. That answers question number 1. Question number 2, Ms. Brazel probably knows the answer to this. Does Smith County want to go first, or are they willing to wait until we take care of our stuff first?
She said that their recommendation, since it is a CPS case, that it would probably be an adjudication and withhold judgment, withhold disposition. since he is a CPS case and they don't know where he's going to be located. She said she would look into moving their hearing since we have a felony.
All right. Sounds like we're getting our ducks in a row. And that helps Ms. Abels, right?
It does.
All right. Okay, Marcus, first, let me see your certificate. Hold it up for me. What does it say?
For demonstrating outstanding character by maintaining level 1 status 7 days, consecutive days, March 6th through March 12th, 2021, President by New Day Services Chaplain.
Sweet.
Good job, buddy.
That
Good
is
job,
awesome.
Marcus.
Okay. Can you do me a favor? Can you maintain that level 10 for me in the back?
Yes, sir.
I know you don't want to be back there, but
I know that too.
but Marcus, what are my options? My options are to send you to the CPS office.
I know I have my stuff there. Last time they didn't give me nothing to do there. I was just in a room all day. I have actually stuff there now, bro. Like I have my stuff there and stuff, bro. Like,
and it's boring, isn't it?
No, it's not now because I got my stuff there. My own attorney telling me she want me to stay here. Like what?
No. I'm talking like at the CPS office. It's boring, isn't it?
No, now it's not because I have my stuff there. Like I have I got like an MP3 and stuff, and they give me real food stuff. Like I have stuff that last time I didn't have nothing. I had to watch the same movies over and over again. I have my own stuff there now.
Well, okay. We're gonna go ahead. I'm gonna go ahead and order that she be detained today. But Miss Abels,
Yes, sir.
Is there a possibility that you and Mr. Reed might be able to wrap this case up sooner so that Smith County is able to wrap his case up on time as it's currently scheduled?
I would imagine.
Okay.
That he and I can. My biggest concern is where are we going to put him? Because if we wrap this up tomorrow, there's no place to put him.
And so that's why I'm going to order CPS to be back here on Friday of next week. We're going to reschedule another 5-day business detention hearing. You need to be back here next week with placement options for him.
Yes, Your Honor.
All right. And I don't want an excuse of, I need more time. No, you've been working on this for a while. I want options next Friday.
And everybody here understands that children with his history are hard to place. We know that because we try it all the time.
Yes, we do.
But somehow or another, we have to find Marcus somewhere to go. Because eventually he's got to go.
Yeah, and I would just like to make note that we have not just the program director, but we have the regional director, and we're working at the state level on this, possibly even spreading out wider. So we are making those attempts, and we do want to see Marcus get into placement.
Good. I look forward to hearing your results Friday of next week.
Marcus, be on level 1 next Friday. Don't make the judge have the only option of prison, okay?
Yeah, I don't want that.
Yeah, I don't want that either. So stay on level 1 this week, and I'll call you or come see you this week.
And Miss Abels, if you and Mr. Reed and the CPS can get something worked out even sooner than that, then you call Miss Kelleher, you get it scheduled. I don't care if I have to stay here till 9 o'clock at night to make it happen for Marcus. Marcus, the reason I'm going out of my way like this, Marcus, for you is because you're level 1.0 and you earn that certificate. And that proves to me that you're trying to make a change. You're trying to do good. And so for kids who are trying to do good and trying to make a change, I'll go out of my way for them. Okay.
All right. I'll talk to Mr. Reed and I'll talk to Marcus.
All right.
Shelly, will you give the CPS guy my number?
Yes, I will.
Thank you,
All right.
Judge.
Thank you. That's going to be the order of the court.
All right. Bye-bye.
I was really hoping they'd have an answer today because they gave the same song and dance last week or 2 weeks ago to Judge Kim. Because I was listening. Okay. Good morning, Jimmy. How are you?
Good.
My name's Judge Porter. We've met before. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Youngblood, is here. The court will take judicial notice of the fact that the court previously determined that probable cause exists to believe that A, you violated your probation that I put you on, and 2, that you've engaged in delinquent conduct that would constitute at least one or more felony offenses if engaged in by an adult. You're level 3, unacceptable in the back. You allegedly have been kicking walls in the back. You're not level 1 outstanding. I'm not going to consider you your release. Anything else, Mr. Youngblood?
No, sir. Those are the reports I've been getting. Our telephone conversations are difficult because there's something wrong with the phones in some of the places back there. But thank you, Your Honor.
All right. Jimmy, I'm going to tell you right now, if you keep up the behavior in the back, you're going to make it really hard for Mr. Youngblood to argue for you to go anywhere other than TJJD. You just need to understand that that's where you're headed if you keep up the behavior in the back that you're engaging in. All right, that's the order of the court. Thank you, sir.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you, Mr. Youngblood.
Okay, apologies for taking over the Zoom earlier.
All right, Samuel Nishimirmana.
Good morning.
Good morning, Mr. Lofton. How are you?
Every day's a holiday, every meal's a feast, Your Honor. So. Judge, while they're giving him housekeeping, I had a case set at 9:30. That was in another court. We've agreed to that, and if the court has time after the detention hearings, if you could call me and I'll get on wherever I am, and I think we'll be ready.
All right, then we'll switch it back to my regular and my regular Zoom meeting ID, and we'll take care of it.
Yes, sir. Just call me whenever. I'll be ready then. So.
All right. Are you Samuel?
Yes, indeed.
Samuel, help me pronounce your last name correctly.
Nishimirmana.
Ah, Nishimir. I just can't do it. Of course, I have trouble with Gaelic names too, and you'd think somebody of Irish descent could actually pronounce Gaelic, and I can't. All right. Samuel, my name's Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Lofton, is here. Do you see him on the screen?
Good morning.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention in our facility. More specifically, back on January 2nd, you were referred by the Fort Worth PD on charges of aggravated robbery and evading arrest. According to the police report, on that date, the police met with the victim who reported that he was cleaning out his vehicle when 2 unknown males walking past his house, then turned around and began walking towards the victim in his vehicle. He directed them to leave. One of them allegedly pulled out a semi-automatic pistol from inside his jacket and told the victim to open the door to his vehicle. The victim refused. The armed suspect pulled back the slide, chambered a bullet, and again ordered the victim to open the vehicle for the 2 suspects. The victim then complied, and the 2 suspects entered the vehicle with the armed suspect in the passenger seat and drove off in the victim's vehicle. The victim's vehicle was spotted by a camera on Oak Grove Road, and police attempted to initiate a traffic stop. The stolen vehicle increased its speed and began changing multiple lanes in an attempt to evade officers. A chase ensued on westbound I-20, and then eventually the vehicle's driver was unable to control the vehicle's speed, causing it to jump a median, striking a pole on James Avenue, and wrecking the vehicle. The police have alleged that you leapt from the passenger seat, so that would suggest that you're the one who had the gun. and then fled on foot, running north on James Avenue, defying lawful orders by the uniformed officers to stop. You were eventually caught during a foot chase and detained, and a Smith & Wesson .40 caliber was found in the floorboard where you had been observed sitting. All right, Mr. Lofton, what are your thoughts?
Judge, I think probation and the prosecutor might have some other things to say first, so.
Oh, okay. Well, I'll note that he's been level 1-0 since yesterday. And that he is scheduled for a hearing before Judge Terry 2 weeks from today. Or no, 2 weeks from this coming Wednesday, sorry. 2 weeks from this coming Wednesday. So given the fact that he's only been level 1-0 for a day, I don't think
I understand, Your Honor.
I don't think I'm yet convinced that if I were to release him, he would not be a danger to himself or the community. Just 1 day on level 1-0 is not enough to convince me.
Yes, sir.
But we'll let Judge Terry handle things a week from this coming Wednesday. That'll be the order of the court.
Yes, sir. May I be excused for a little bit? Thank you, Judge.
Yes, sir. Thank you. Good to see you, Mr. Lofton. Heath, Montreal Page. That's one of those police reports. The more you read it, the worse it gets. Yeah. Good morning, Mr. Page. How are you?
Good.
Mr. Page, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Gladstone, is here. Do you see him on the screen? All right. The court will take judicial notice that it has previously determined that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. Let me cut to the chase, Mr. Page. Did Judge Kim go over the detention levels with you?
No.
And before I can even consider your release, what's your level supposed to be? 1 outstanding, right? What's your level in the back?
2A.
Uh-huh. Does that qualify as 1 outstanding? So what am I supposed to do today? Detain you or release you?
It feels though to me. You supposed to detain me.
Yeah. Uh-huh. And why?
Because I'm not a 1-0.
Uh-huh. Because if you're not a 1-0, then I know you're not following the rules in the back. And if you're not going to follow the rules in the back, you're not going to follow the rules at home, right? All right. That'll be the order of the court. Thank you, Mr. Gladstone.
Thank you, Judge.
All right. Valerie Ruiz. Good morning, Mr. Sierra.
Morning, Judge. How are you?
Better than I deserve. Are you Miss Ruiz?
Yes, sir.
Miss Ruiz, my name is Judge Porter. The law says when you're brought into our detention facility, you must see a judge within 2 business days to determine whether or not probable cause exists to believe that you engaged in delinquent conduct. This is a detention hearing to determine if you should remain in our detention facility or be released to a parent or guardian. You have the right to remain silent. You also have the right to an attorney. And I've appointed Raphael Sierra to be your attorney. Raphael, if you could introduce yourself to Ms. Ruiz.
Ms. Ruiz, hi, I'm Raphael. I'm your attorney.
Hi.
All right. According to the police report, way back in February of 2019, you were referred to our department, the Fort Worth Police Department, for a misdemeanor assault causing bodily injury that allegedly took place at a metro facility. Officers were notified that you had assaulted a male classmate between 2nd and 3rd period. The officers looked at school surveillance video, were able to see you allegedly approached the victim, attempt to strike him with a closed fist, but he initially got away. However, you continued after him, and then thereafter appeared to strike him 2 times in the back of the head as he walked away. Now, more recently, back on yesterday, March 11th, around 3:45 in the afternoon, Arlington Police Department officer was running plates when he hit a plate that came back with ticket warrants. A traffic stop was conducted, and the officer could smell marijuana coming from the vehicle. You were identified as the driver, even though you had no driver's license, and you handed over a blunt when asked if there was any THC in the car. Officers then searched the car and found a baggie of THC when the car was searched. The total weight of that marijuana was 6.6 grams. All right. So the court will find that probable cause exists to believe that you engaged in delinquent conduct back in February of 2019, as well as yesterday, sufficient to warrant your initial detention. That's the first thing. Second thing, does she have a parent or guardian here today?
Yes, her mother's here.
All right, Mom. Mom, what's going on? Why has she been on the run for 2 years?
I wasn't aware of that. They told us that we're going to send us some information. They said they did, which I don't remember. And I don't remember about it. I'm a single parent. I work most of the time. She wasn't on the run. If I knew about that, I would have taken her to court. She knows that whatever she does, she has to deal with it, and she has to be responsible for her actions.
Your Honor, can I say something?
Your attorney, Mr. Sierra, probably doesn't want you to say anything. He wants you to exercise your constitutional right to remain silent. However, Mr. Sierra, would you permit your client to ask the court a question, not make a statement, but ask the court a question?
Of course, Judge.
Ms. Ruiz, your attorney's advice is to not say anything, but he will allow you to ask a question if you want to ask a question. Do you wish to ask a question?
No, sir.
Okay. Let me check on something. Okay. Mom, do you know where your daughter's getting the marijuana?
No, sir.
Were you aware that she's been using marijuana?
No, a while ago, and she said she had stopped.
Okay. Do you know anything about the traffic tickets associated with the vehicle that she was in?
Not at all, sir.
Okay.
I was at work. I didn't even know she had gotten arrested. They called me like around 8, and they let me know that she was arrested and that she had marijuana with her.
Okay.
Because she didn't even call me.
Okay. Mr. Richmond, what are your thoughts?
Well, Judge, given that I note from the report that they failed to appear to 2 intake appointments, and seems like this is the only way we could get her to show up. It sounds like there's a unlikelihood she would show up if we released her. Further, I note the court often detains kids who test positive for drugs, and she tested positive for marijuana yesterday. So I would ask the court to detain.
Mr. Sierra, what are your thoughts?
Your Honor, given the circumstances, I will refer to the court's decision, Your Honor.
All right, Ms. Ruiz, you knew about the 2 intake appointments, and you knew about the traffic tickets. I mean, so it sounds like you just want to do what you want to do when you want to do it without obeying the rules of either your mother or society. And so, you know, that's a classic case where you're a danger to yourself or others. So I'm going to order your detention. We will revisit this case in 10 business days. Let me tell you something. Between now and the time you come back for your next detention hearing, we have different behavioral levels in the back. Level 3 is the absolute worst, and level 1 is the absolute best. Right now, because you're new to the facility, you're at level 2. You want to get to level 1 and maintain level 1.0. If you do that, once you get to level 1.0, if you maintain level 1.0 for 7 calendar days, I'll authorize her release on the electronic monitor. Okay? But if you get to level 1 outstanding and you dip down to level 1 acceptable and then get back up to level 1 outstanding, that whole process starts over. You've got to get it and maintain it for 7 days, and then I will allow your release on the electronic monitor, okay?
I really can't say nothing.
You'll want to talk to your attorney, Mr. Sierra.
I'll call you right after.
And tell him what you want to say, and then he can tell me, okay? That's going to be the order of the court. Thank you.
Thank you, Judge.
All right, Destiny Sanchez.
Give us 1 second, sir.
Good morning, Mr. Beaver. How are you?
Great, Your Honor. Good morning.
Good morning, Miss Sanchez. How are you?
Good morning, I'm good.
My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Beaver, is here. Do you see him on the screen?
Yes, sir.
Good morning.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your detention. Let's see. Ms. Rojas, are you here?
Your Honor, I'm here for Mrs. Rojas.
Oh, thank you, Mr. Lahara. Is this her only referral to the department?
Yes, Your Honor.
All right. And is that mom in the family room?
It is Mom. Yes, Your Honor.
Okay. I'll note that Destiny has been level 1 outstanding since March the 1st. Mom, what are your thoughts about whether or not to release Destiny? Do you want her to come home?
I don't want her to come to my house. But according to Ms. Rojas, I only have 3 options, she said, which was my house, another family member's house, or CPS.
Okay. Is there another family member who's willing to take her in?
I do have my parents that want to take her, but I don't feel safe with that decision.
Okay.
Your Honor, may I please question Ms. Washington?
Please, Mr. Beaver, please.
Thank you, Your Honor. Good morning, Ms. Washington. So if Destiny were to go and live with your parents, I mean, does she have a good relationship with your parents?
Yes, she does.
All right. And where do your parents live?
1 block over from my house.
All right, great. And you understand that Destiny has been one outstanding, the best level of behavior since March 1st while she's been detained?
Yes, I do.
Okay. So keeping that in mind, do you believe it would be fair to her and I guess your entire family if she were to leave the detention center and have a second opportunity living with your parents?
To be honest, I don't know. Pretty much with her assaulting me over a cell phone has been the last straw for me. I have done several things in the past to get her the counseling and the treatment that she has needed. I gave her many chances over and over again. She got suspended at school 3 days before she assaulted me. And I just honestly don't know at this point if she's actually telling the truth on wanting to change or if she's just playing the act like she did before in the past.
Thank you, Ms. Washington.
Okay. Mr. Beaver?
Your Honor, we would request that Ms. Sanchez be allowed to leave the detention facility and to remain with her maternal grandparents. If the court has reservations, then an electronic monitor, I think, could help alleviate some of the concerns that the court may have. But she has demonstrated that she is able to follow instructions by being at level 1 outstanding for over 10 days.
Destiny, you've maintained level 1-0 for 11 days. If I were to release you to your grandparents, can you promise the court that you will maintain level 1 outstanding for your grandparents?
Yes, sir.
And that you will follow their rules?
Yes, sir.
Okay. If you don't follow their rules, and if something bad happens at their house, what do you think is going to happen?
I'll come back.
Yeah. So I'm going to authorize her release to the grandparents. Mom, if you get a report or find out that she's not maintaining level 1-0 for grandparents, then please call Ms. Rojas, okay?
Okay.
All right. I'm going to give her this chance, though, because 10 days at level 1 outstanding is not easy. And that she's earned this chance. All right?
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you,
May I be
Mr. Beaver.
excused?
Yes, sir.
Thank you.
Victorian, Lindell, Titus. How are you, Mr. Titus?
I'm good.
Mr. Titus, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Taylor, is here. Do you see her on the screen?
Yes, sir.
All right. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. So the court will not go into the allegations underlying your arrest. You got to level 1-0 today, right? Well, I can guarantee you, your attorney doesn't want you to say anything. Ms. Taylor is vigorous in defending her client's constitutional rights. Okay. All right. You're charged with a really, really serious offense, Mr. Titus. And you also have a secondary referral for a second firearms-related offense. Just getting to level 1-0 this morning is not enough yet. I'm too scared that if I were to release you, you'd be a danger to yourself or others. Ms. Taylor, what are your thoughts?
Judge, we come here every 2 weeks. It's my understanding the lowest his level has dropped, and he's been here since November or earlier. Long time. Lowest his level has dropped has been a 2. Again, is my understanding, and I'm sure Mr. Kroll will correct me. I think he's been dipping between 1A and 1O. I suspect when he I talk to him quite frequently, and I suspect when he raised his hand, that's what he wanted to indicate to this court, is that he's just come up. He's been right there at a 1A. And now today he is a 1O. And we, again, like we do every 2 weeks, we are respectfully requesting his release. I know the courts have been provided with recommendation letters. I know in previous hearings, his family has indicated that, you know, they can keep him safe. They're not in a neighborhood where he would be in danger, and that certainly the public wouldn't be in danger. So we respect the court's decision, but we are, again, as we are every 2 weeks, respectfully asking for his release.
All right. Ms. Taylor, your arguments are not without merit, and the court does take those to heart. But I've got to weigh the danger to the community against his consistent behavior in the back, and consistent by our standards is the expectation that he maintain that level 1 outstanding. So in this case, at this time, I'm not prepared to authorize his release. Yes, Mom, you've got a question.
What's the difference between a 1O, I guess, or a 1A?
Usually, if they have absolutely perfect behavior in the back, they get to level 1 outstanding. They can lose points for different violations in the back. And it's not just like, let's say they had their mask off the ear for 3 seconds. That's not enough to drop them from 1 outstanding to 1 acceptable. It usually takes a couple of things put together to drop them from an outstanding to an acceptable, but it's on a point system in the back, and they're told about that point systems and how all that works. And so it usually takes a little bit more than, you know, just one thing. When we see kids drop from 1 outstanding to 1 acceptable, and I'm not looking at your son's case, I'm talking about just in general. A lot of times we see it's because kids are talking out of turn in the classroom, but it's not just one time. It's usually, I see reports of at least 3 times in the classroom, plus some other conduct that causes them to drop from 1 outstanding to 1 acceptable. So let's see. Mr. Crawl?
Yes, sir.
What was the basis for him dropping from 1 outstanding to acceptable and then getting
This
promoted?
last time was a violation for passing out personal information.
Ooh.
So whether that's email, Snapchat, phone number, whatever that was, they deemed it personal information. And that's a violation of standard policy in detention.
And what do you think the wisdom behind that policy is?
The easiest way to express it is compliance with standard probation terms. You don't want others communicating through the system.
Because kids who are on probation are not supposed to hang around other kids who are on probation, correct?
Correct, sir.
And a lot of times back in our detention facilities, we may have kids that belong to different, what we call criminal street gangs. Is that correct?
Correct.
And if one kid gives information to another kid, it's possible that second kid could give that personal information to a third kid who might be of a different gang member than the first kid, correct?
Correct.
And then suddenly that first kid's personal information gets to that opposing gang, and then that third kid gets out and he shares that information with all of his gang members, and suddenly we have a drive-by for the first kid's house and mom and dad are in danger, right?
Correct.
We've actually had that happen, haven't we?
Yes, sir.
All right. So does that make sense, mom and dad? All right. So thank you, Ms. Taylor. Just for today, we're going to go ahead and detain him, all right?
Thank you, Your Honor.
Thanks, everyone. Dania Johnson.
Can't be excused, Judge.
Yes, ma'am.
Thank you. I'll call and make an appointment.
It's good to see you. Thank you, everyone. Our last detention hearing will be in person. I'll continue running the camera so that you'll be able to listen in. but there won't be the video feed of all the participants. And Ms. Brazel, if you'd like to join us in person, you may, or you may stay where you are. It's up to you.
I'll come down.
Same thing for you, Mr. Richmond. Totally your option. Oh, you had to wait till the very end. That'll work. Yeah. We'll wait for Mr. Richmond to get here. You have a seat. It's okay. I'll go over the preliminary stuff. Miss Johnson, my name is Judge Porter, and the law says when you're brought into our detention facility and initially detained, you have to see a judge every 10 business days thereafter. We're actually doing yours more frequently, so we're doing yours every 5 days. So this is your 5-day detention hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Hopkins, is here. I'll let you know if there's something you want to say, don't just blurt it out. Instead, tell Ms. Hopkins first, and that way she can advise you on whether or not you really should say it. Here's why. You see that man over in the corner with the computer? That's the prosecutor, Mr. Richmond. He's taking notes. And so anything, whatever you say at this hearing can't be used against you in the future, it may help Mr. Richmond find more information about you that you may not want him to know. All right? Now, in the grand scheme of things, do you want to help Mr. Richmond or do you want to help your attorney? Good choice. So don't blurt anything out. Tell her first and then she can tell me that. Will that work? All right. Now, according to the police report, back on February 14th, you were referred around 9:30 at night because police were dispatched to Millwood regarding another kid damaging stuff at the nurse's station. Police detained him, but in the process, the police say that you were yelling at them and attempted to interfere. A nurse was holding you back as an officer stood next to him. According to the police report, you then spit on the officer, hitting him on his cheek. You then kicked him in the groin, causing him pain. And then thereafter, you were referred to our department. Okay. Shelley, is she on probation in Dallas County?
Yes.
Okay. Ms. Hopkins, what are your thoughts?
Your Honor, we would love for Amari to be able to be released today. She has been on level 1O. Additionally, we have been coming back every 5 days because she is TMC of state. And they have been having difficulties finding her replacement. And they have secured a placement. However, that placement is waiting to see if we are going to release her today or not. And so I believe the CPS caseworker, she was here, and the CPS supervisor, I believe, is on Zoom.
Yes, she was. Oh, yes, she is. Okay.
The other thing I would like to remind the court of is that Dania was off her medication for more than 2 weeks. And since being on her medication, she has is completely different individual. And she is ready.
All right. Tell me about the placement options. Talk louder. Here, put your mask. You're 6 feet away from everybody else, so.
Right now, there's an HCS home that is willing to use her. It is in Fort Worth. But right now, we're just waiting on confirmation so we can issue. But it is approved. So we have a placement secured for her.
What do you think? You don't know? Do you want to give it a try or do you want to stay in detention? All right. Ms. Brazel, what are your thoughts?
I just, I'm holding my weight. The information yesterday, called to the Sanchez and I while she's here. I just want Dania to know if another incident happens, she may be brought back here, and we'll have another detention hearing like we're having today. And, Your Honor, she knows nothing of this HCS house, which may be why some of her hesitancy.
That's understandable.
I just learned it probably while she was walking back here. So we haven't, to let her and the court know, an HCS house is a home that has special level of training with individuals, as well as they have a different, it's almost a 2-on-1 with the residents, and it's more of a home structure than a hospitalized or any other thing. So she'll be in a home in Fort Worth with individuals there that can help her get through life. And I think this is a wonderful opportunity for her, and she will enjoy it as well.
Is it okay if I ask her a few questions about her medication?
Yes.
Okay, since you've been back in detention, have they been teaching you about your medication and how it's important to take it on time every day?
No, I already know about it.
Okay, well tell me about it.
In the morning time, I take my pills at the same time.
Mm-hmm. And what time is that?
It's around 7:30, 8 o'clock.
Okay.
The nurses always come in at 8 o'clock, and I'm the first one who takes my meds, so I always take it at 8 o'clock. At nighttime, I take 200 milligrams of Seroquel.
Okay.
And I take it at 7:30 every day.
Okay.
The medication is for my mood,
Mm-hmm.
and like it helps me to like stay calm throughout the day.
And let's say if you go to this home, but you get to about 7:30 at night and they haven't brought you your medicine yet. What do you think the right thing to do is? There we go. Exactly. And so you're going to be at a new setting. So I want you to be an advocate for you. So if you're used to taking your medicine at a certain time, when you get there, tell them that. Tell them, I'm used to taking my medication every morning between 7:30 and 8, and that really helps me, and I'd really like to stay on that same schedule. And sometimes they may forget, because I forget sometimes with my stuff. So you be an advocate for you, and you stand up for you, because that's really helping you, okay? Will you do that for me? All right. You've been level 1 outstanding in the back. So I want you to make a promise. You'll take your meds like you're supposed to. You'll be an advocate for yourself. Talking, no fists, just talking, right? And third thing, will you maintain level 1O at the new placement for me? All right. Then I'll authorize her release today. Thank you, Ms. Hopkins. Were you able to get all that, Ms. Littlefield?
Yes, that was, well, mostly. We're planning for her to leave. We just want her to understand it is an opportunity.
Yes, ma'am. Yes, ma'am.
It sounds like you made a very good point.
Thank you.
Thank you.
All right, that concludes today's detention hearings. Everyone have a wonderful, happy Friday.
Thank you.
Judge.